This is Philip Morris's response. So, in their memorandum in support of their motion to dismiss, defendants, which Philip Morris explained that HCMC's complaint should be dismissed because it is premised only on a wholly implausible allegation. Combustion occurs in IQOS devices specifically engineered to make combustion impossible. That is contradicted by the sole evidence plaintiff relies on to support it. For that reason, under well-settled Supreme Court, 11th Circuit, and Federal Circuit law, the complaint is implausible on its face and should be dismissed. Hcmc's opposition does not meaningfully address any of this. Instead, in a brief Latin with misstatements of the law concerning the relevant pleading standards and mischaracterizations of defendants' arguments, Hcmc hides behind the procedural posture and non-existent claim construction dispute in an attempt to convince the court to let its case to get to discovery. The court should decline imposing burden the court should decline imposing that burden on the parties. Hcmc's deficient infringement theory requires the court to make unreasonable inferences and ignore unambiguous statements in the very evidence Hcmc proffered. Hcmc cannot prevail on the merits, and it should not be given the opportunity to use the judicial process as leverage to extract a nuisance settlement. This case should end now. So this is Philip Morris. This is okay. So that's that. I'll leave it here so you guys can go ahead and read it while I explain. But basically, what Philip Morris is explaining here is that what Hcmc is claiming is that the combustion occurs in IQOS devices that's specifically engineered to make combustion impossible. And we've gone over this in previous videos that Philip Morris has kind of almost, it seems like they didn't even look at Hcmc's patent before they made the IQOS device, because that's pretty much exactly what Hcmc's patent explains and what their patent is. And in this motion, I guess this is essentially a memorandum in support of their motion to dismiss. They're basically saying that Hcmc shouldn't even get the chance to go to discovery, which is basically where you lay out everything to in the trial. And they don't think they should even get the chance because of the non-existent claim construction dispute that they're having and just the overall mischaracterizations and pleading standards that Hcmc is claiming. I think it's honestly total BS on Philip Morris's part. Again, this is just my opinion. But why would Hcmc just put all their eggs in a basket before it gets to discovery, right? Because then if it doesn't get to discovery, then they wasted their time. In my opinion, I believe this is somewhat of like a scare tactic for Philip Morris against Hcmc. And I actually can't wait until Cozen O'Connor and the representation for Hcmc responds to this. Again, you can see here, Hcmc's strained defense of its direct infringement claim only confirms its implausibility. Hcmc does not and cannot contest the central point of defendant's opening brief that the MRTPA attached as Exhibit J to plaintiff's complaint directly refutes the conclusory combustion allegations in the complaint by repeatedly and unambiguously stating the combustion. So basically, for me, it's like Hcmc and Philip Morris, they're in this lawsuit infringement case. Philip Morris, in my opinion, they have a lot of money, like a lot of money. So I'm sure they obviously don't want to settle, but this is just another, I guess, step in what needs to happen before that settlement happens again, in just my opinion. I kind of expected something like this, more of fighting back from Philip